So, a very good evening to everyone present here. I am Rithi Chandral, Chief Operating Officer at Law Internships Online Law School, and I wholeheartedly welcome everyone for a live and interactive session on how to draft an application for maintenance under Section 125 of CrPC. So, the resource person for today's session is Mr. Tarun Agarwal, sir. He's a law graduate from National Law University, Delhi, and is currently a member of the Bar Council of Delhi. So before starting his practice as an independent counsel, he has had a wide experience of working with some of the top law firms and esteemed law chambers of the country, such as Cyril Amarchand Mangaldas and law chambers of Kapoor and Trehan. In his current stint, he advises and represents clients on diverse issues ranging from complex corporate and commercial matters to intellectual property, insolvency and bankruptcy, real estate, domestic and international arbitration, white collar crime, and environment matters. He has been a trusted counsel to several startups, multinational companies, non-profit organizations, societies, trusts, and various private individuals, to name a few, such as Flipkart, Ed2Cares, Consumer Unity and Trust Society, and etc. He is also an off-counsel of CAM, J. Sagar Associates, and other reputed law firms for the niche and high-stake matters in Rajasthan. He is actively required by his clients to appear before the Supreme Court of India, High Courts of Delhi and Rajasthan, District Courts of Delhi and Rajasthan, and various other tribunals. So apart from work, sir, to keep himself physically, mentally, and spiritually aligned with his life's purpose, he keenly practices yoga and Australian Buddhism. And in his free time, he enjoys traveling, reading, and playing chess. We welcome you, sir.
Thank you so much for that kind introduction, Vidhi. I hope the students did not get bored with the introduction's length itself.
No, sir. So without delaying any further, let's begin the session for today. I just want to request the students, if you have any queries, please feel free to unmute yourself. But before that, please raise your hand, or you can even type out your queries in the chat box. Thank you so much, sir. You can proceed ahead with the session.
Yeah, thank you so much, Vidhi, for that warm welcome. So, hello everyone. It's a great pleasure to be here, and I really hope that we are able to, together make it a very informative experience and session that, and all of you, take away at least the key points of drafting an application. So, by end of this session, my aim would be to not only take you through the basic ingredients of Section 125 CRPC, but also to, give you a general approach and to acquaint you with the general approach of how to begin a draft. And I really hope that this may be helpful to you in any sort of the drafting that you may undertake. And because the basic principles and key ingredients are very similar, the approach is similar. It's all about having the knowledge of the provision and a clear understanding of it, and then we can draft any application or petition. So before we begin the session, I'll just give you a brief overview how usually we approach a draft. And wherever you have any questions, you may either drop it in the chat or you can raise your hand, and Riddhi can just let me know, and I will stop. No issues about that. So may I generally know if the students have read through the CPC, have completed the CPC course in their college? If someone can just raise your hand and just confirm yes or no. And
yes, sir.
Okay, thank you. So I think most of you are generally already aware about what is a plaint, what is a petitioner, what is a respondent, what is an application, what is the difference between an application, the petition. So these general things I think you are already aware of. So straight away coming to the key points is that whenever a client comes to you, so you always assume that you are an independent counsel, and if you have to approach a draft, how will you approach it? So the first step is to always listen to your client patiently and thoroughly with keen attention. because as a client, it's usually you are not aware as to what is important, what is not important for your case. So it is always the lawyer's role, to guide the conversation and the client conference in a informed direction. So, in order for you to, steer the conversation in a fruitful manner, a lawyer is always required to know the provision, to know the latest development around that provision. What is the latest position of law laid down by the Honorable Supreme Court, sorry, or the concerned High Court. So, assuming a client approaches you for drafting, or representing him or her in a case for maintenance. Now, what will be your role and how will you begin with that? First of all, you will sit with the client and listen to the facts of the case, their entire story, because you need to have the background of the parties, the case, and what actually they want out of this legal case. After you have understood the case, second step would be to go back and study the provision, thoroughly go through the latest judgments, and also look for facts and situations which are similar to your case and wherein courts have already granted reliefs in a similar case. Once you have done that homework, then the third step would be to draft the case for your client. Now, when you begin to draft a case for your client, you need to, thoroughly understand three things. First, the understanding of the provision. The biggest mistake most of the lawyers do is that they straight away jump to drafting or discussing the case with the client, without having even the basic knowledge of a case. So as lawyers, we are not supposed to, and even we are not expected to know the entire each and every section thoroughly. So it's all, and law is an evolving, law always keeps on evolving. And in such a, now we live in a age of information where we are, the information is easily available and accessible. So we cannot, make an excuse of not having the resources to do our homework and to do the thorough reading of the provisions. So first, you are required to read the provision, understand what are the basic ingredients that you need to satisfy and plead in your petition or application. Because if you fail to state the basic facts and the key ingredients of the provision under which you have approached the court, on the very first day the court will question you on the maintainability of your petition or application. Court will straight away, on the first hearing of a case, court will straight away ask you to satisfy the learned court as to why this application or petition is maintainable on the first, instance. So in that case, the first hearing is a very brief hearing, and your entire aim is to get it admitted and get the notice or summons issued to the other party. You have to satisfy the court that there is a prima facie case. You satisfy all the basic ingredients of the provision or the law under which you have approached the honorable court, and that you have a good case, and that once the honorable court issues summons and the trial proceeds, you will be able to satisfy the honorable court, and there are high chances that you will have a fair case of getting the relief that you have sought in that case. Now, once this third step is completed, then you can begin your draft. Now, jumping to the now to I'll now in this session, my aim will be to take you through the basic ingredients of the section. What are the provisions which apply and lay down the procedure for filing such a maintenance petition? Third, to take you briefly through the latest judgments and the key judgments which evolve around this section. And lastly, I will showcase you the basic draft of a petition as to how you can draft it and how it usually looks like. So to begin with, I'll just screen share my PPT with you. Give me a second. Yeah. Can anyone confirm if it is visible?
Sir, it's completely
Yes, it's
visible.
visible.
Okay.
Yes.
Thank you. Yeah. So as I mentioned, I'll just briefly, I have already completed the introduction. My second objective is to give you a brief background of the relevant provisions as to what are the essential ingredients. Then the next is the significant judicial precedents. We will just discuss them if time allows us. Then next is the essentials of drafting a petition under section 125 CrPC, and then I'll show you and take you through sample draft of a section 125 petition. So just to give you a brief background of what section 125 entails. So CrPC, as you all know, is a criminal procedure code and entails the procedure for all the criminal cases. Now usually we need to understand what is the background and usually in what circumstances such an application is filed with the court. Usually such an application is filed in those cases where a man has divorced his wife, or a wife is living away from her husband's family. Her husband is not taking care of her or not giving her any expenses to take care of her. So this is usually happens in most of the cases. So as the jurisprudence has evolved, the primary objective of this application is to safeguard the interest of the children, the wife and elderly parents who are not able to maintain themselves, right? So moving on to the section itself, as I've explained, the key objective is to prevent vagrancy and destitution of a wife, minor children and parents. Now what are the essentials? Who can initiate or file this application? So there are broadly four category of persons who can file this application and can seek maintenance under this provision. First is a person's wife. Second is a minor child, whether legitimate or illegitimate, from a marriage or from a long-term relationship with a woman. Third is major child, a child who has attained the age of 18 years and who is not able to maintain herself or himself. Then the last category of persons is father or mother. Now, in all these four cases, the basic condition is that whoever files this application, they have to prove that they are unable to maintain themselves. Now, what does it mean? I'll explain you further in the later slides. Now, once we have understood who can file this application, the next question is where you can file this application. So that question is answered in section 125 and 126. So section 125 first lays down who can initiate this application, who can file this application. Then this section further talks about what is required to successfully maintain this application. So that answer to that question is that one has to prove that the man has neglected or has failed or has refused to maintain or take care of his wife or his children or his elderly parents. Now what is required to make such proof, we'll come to that later. Now under this section 125, if we talk about what are the powers of a magistrate, then such magistrate may either order a person to make monthly allowance. Second, the magistrate has also the power to grant maintenance to a female child till the age she attains majority if her husband is unable to maintain her. Third important power that a magistrate has, that suppose assume a scenario wherein a wife is living in destitution, is has been thrown out of her matrimonial house by her husband or her matrimonial her in-laws. In that situation, there might be a case where a wife does not even have any basic source of income and she's not even able to take care of her basic allowances. So in those cases, this provision also provides that additional safeguard to such women, that till the time that entire case is decided, in the interim, court is given the power to grant maintenance on an interim basis. What does an interim basis means? Interim means temporary basis. So in the meantime, because in India, as we know, there's a huge pendency of cases and courts are always overburdened. So what happens is that such cases also takes almost a year or 2 years to get resolved. So in that case, if we allow a woman or a needy child or elderly parent to suffer without any basic maintenance or allowance, then the entire purpose will be will fall down. So to safeguard the interests of such person in those situations, provision specifically provides that in the meantime the case is decided, court even has the power to give temporary allowance, right? And such an app, and this can be done by way of a simple application to the court stating that I am and with along with a proof that I am unable to maintain myself, I don't have any source of income, and therefore in the meantime this petition is disposed of, I should be granted temporary allowance. And this application has to be is required to be disposed of within 60 days. So this section is actually very benevolent and very favorable to the applicants. Now as we know in India, there has to be some enforcement procedure for such cases. So the provision says that in case a person fails to comply with the court's order, in that case the person may be put to simple imprisonment for a month and may be fined also. So now moving on to the next section, which is section 126, which deals with the procedure of filing such a petition, which basically talks about the jurisdiction and what kind of evidence may be produced in support of this application. Then again, this section is very important because it explains which court will have the power to decide such application. Now, giving you a hypothetical scenario, suppose A and B gets married in Delhi. B belongs from Punjab, her family is from Punjab. A and B gets divorced, and B is forced to live in destitution for some reason in Rajasthan, for example in Jaipur. Now in that case, if that woman decides to file this application and seek maintenance, then the first question comes to mind is where she can file that application. Should she file it in Punjab, from where she belongs? Should she file in the concerned court of Delhi, where she was married into? Or whether she should file it in Jaipur, where she is currently residing? So all these questions are answered in section 126 as to which court will have the jurisdiction. So again, as the objective of this provision is to help such a woman or a child or a elderly parent, again the jurisdiction clause is also very wide. And Supreme Court has also from time and again held that such person, assuming a wife is filing this, then she can file this case, first option where her husband is residing or where she last resided with her husband, or if the petition is filed by an illegitimate child, then he or she will have the right to file the petition in the jurisdiction of a court where his or her mother last resided. So in our case, in the example that I gave, a wife will have the right to file this application in Delhi or in Jaipur, because where she is currently residing. Hope everyone is with me as of now.
Yes, sir.
Okay, so I'll move on. Now the next question comes as to what kind of evidence is required to support such kind of petition. So usually these whatever evidence that we collect has to be crystal clear and has to show whatever we are stating in a petition. For example, if a wife is saying that she got married to so and so person, then that marriage, the fact of the marriage has to be supported by the marriage certificate, because as we colloquially keep on hearing that कानून कागज मांगता है, right? So whatever you state in your application or petition has to be supported by a document. बिकॉज कानून अंधा है, और कानून सिर्फ और सिर्फ आपका कागज देखेगा और कागज के बेसिस पे ही ये मानेगा कि हाँ जो आपने फैक्ट स्टेट किया है वो सही है या गलत है. Now, at the same time, one interesting fact also that now one can ask a question, that if a person is is in such a condition that she does not even have the means to file this case, then how will she, afford the cost of such an application? So in that case, the provision also, this section 126 provides safeguards and says that even the cost of the litigation also be liable to pay such cost if the court. So as we have seen till now, that till now we have understood who can file this, who can, the children or the elderly parents who are unable to maintain themselves. Second, we have understood where such beneficiaries can file this case. Third, we have also understood, in case a person is unable to maintain them herself or himself and does not even have the cost to, afford this, then court will grant the cost also. So in all, it's a very, very, it's a social, legislative, social legislation, and it's very, favorable to the concerned people. Now, next important, aspect of these proceedings is that, for example, today a husband is earning 1 lakh a month and wife is not earning, a single penny, and today she files a case, and after she has a very strong case, and court suppose today grants her a maintenance of 25,000 a month, considering all the facts and circumstances. Now tomorrow, maybe after 2 years there might be a situation like, in last 2 years when COVID hit, so there might be other circumstances also, wherein due to some circumstances, whatever, recession hits, or there might be a natural calamity, whatever reason, XYZ reason, because of which a person suppose loses his job, or his salary is reduced from 1 lakh to suppose 50,000. And now in that case, if a person is still compelled, or is still required to pay the same amount of maintenance, then in that situation, it might be unfair to him, right? So in order to cater to such situations, uh, our legislators have provided section 127 of CrPC, which deals with the alteration in allowance. Now what does it mean, and how it can be used? Now, in the appropriate circumstances, like, I gave one example. So if such a situation arises, then that husband tomorrow may approach the court and file an application seeking alteration in the amount of the maintenance on the, grounds as I explained to you. So such application may look like, wherein he states and submits to the court that, earlier when you granted that amount of 25,000, I was earning so and so amount a month. Now today, after 2 years, I've been continuously paying her, but now I have lost my job, or maybe I've switched to another job where I'm earning 50,000 a month now, and I have my elderly parents to take care of. I'm also maintaining my kids who are living with me. So therefore my monthly expenses itself, are about 30,000, and therefore I'm not in a position to pay 25,000 anymore. So in that case, if a husband is successful in proving all these facts, then in that case a court may be happy to alter the amount and reduce the amount from 25,000 to 20,000. Now there may be myriad of circumstances. For example, as we discussed, the essential ingredient of section 125 is that a person has to be unable to maintain herself or himself. So now another example of another facts and circumstances when this provision can be employed is, for example, after 2 years, a wife starts earning a handsome salary of 2 lakhs a month. Suppose she gets, she is lucky and she gets a job, a very good job, and starts earning 2 lakh a month, which is, maybe more than the salary of your husband. Anything can happen in India. So in such circumstances also, the husband will approach the court and will say, that now my ex-wife is able to maintain herself. She is well educated and now she is doing a job, and she no longer requires my assistance, right? She does not require my help anymore. So in those given circumstances, court can cancel the maintenance order also. So court can either alter the amount in the given circumstances. Second, court can also cancel the maintenance order completely and set aside any requirement of paying that maintenance or allowance. So as I have, as you can see on this screen, there can be different other circumstances also. For example, a woman has remarried, or a woman has received the whole sum which was payable on divorce under any customary or personal laws. For example, in Muslim law, at the time of talaq, or at the time of divorce, a custom allows to get a certain sum of money as an alimony. So in those circumstances, if as a customary practice, or if the personal laws allows, in that case, if husband has given a certain fixed amount, then in that case also he can apply to the court and seek cancellation of the maintenance order. Or there might be a circumstances again wherein post divorce, both the husband and wife mutually decide to close this arrangement, and wife surrenders her maintenance right. So this was briefly about the relevant provision which deals with the maintenance under CrPC, which is Criminal Procedure of Court. Now, if all of you have understood so far, then we can move to how to draft. So basically, the next slide deals with the significant judicial precedent, but I'll come to that later. Before that, I want to take you straight to what a basic draft looks like, because this is very important. I'm sure all of you are well equipped to do research, and so we'll come to that later if time allows us. So now that you have understood what are the essential ingredients of the sections that are there under CrPC, now let's jump to the main portion of our session, which is what are the essentials of drafting a petition under this section. Now, just give me a second. Yes. So, before now you get to drafting a petition, you need to have certain basic details. First, you need to have the details of the parties, basically on whose behalf you are filing this, name of the person, her complete address, details, etc. Then you need to have the details of the respondent against whom you are seeking the compensation, or against whom you are filing this petition. Then you need to have all the documents that you will file or place on record to support your petition. Now, what can be these documents? These documents will include the registration certificate, any document which can support that you are unable to pay your basic expenses. That today, for example, in India, there are a lot of instances that we see wherein, a lot of housewives, after divorce, they are completely left in the lurch, because unfortunately, because they have been working as a housewife, they have not been able to, gain experience of working, and they are, it's very difficult for them to seek employment. In those cases, a housewife needs to show that she is not earning, and she has to state this on the affidavit. Next piece of evidence can be, if you are lucky and if you have the, any document pertaining to your husband's job or salary slip to showcase that how much he is earning. Next document can be, to showcase that, for example, your husband is earning X amount, and he has no other liability. For example, he is not living with his parents, and he does not have to support anyone else And so these are the relevant factors that you need to state in your application. Now, what usually a good draft contains. A good draft contains name of the court. First, it starts with the name of the court. Then second, it has the title of the parties. Next, it has the subject of the petition, that maintenance petition under section 125 CrPC. Next, it has the index. Next, it has a list of dates in a chronological sequence and a synopsis of your entire application to help the concerned court to immediately understand your case. Now, before I just explain you what are the relevant factors and key considerations that you need to keep in mind while you are drafting a 125 application, I'll just screen share a basic draft of petition for your better understanding. Yeah, so is it visible?
Yes.
Yes.
Okay, great. So as we just discussed now, this is the title of the court, right? The As I mentioned, I gave you an example where a wife is filing a petition against her husband in Delhi. So name of that concerned court will come here on the top of the file. Then the case number will be assigned to you by the concerned court once your case is successfully filed. Then next comes the name of the parties, Mrs. So and so, the petitioner, versus Mr. So and so, the husband or respondent. Then this is the title of the case. Then comes the main part of the petition or application. So this is basically, I have not included the index or synopsis. I hope you might have seen it in your previous internship, how an index and synopsis looks like. So, and if you will want, I will share that also. I'll share it with the Riddhi and she can circulate with all of you. So this is how normally a draft looks like. This will contain the basic details of the parties, the petitioner, then the facts of the case. Then comes the jurisdiction clause, that you have to state it specifically, that why this court and how this court has the jurisdiction. Next comes your prayer clause, that what are you seeking from the court. So I have kept this draft very short and simple, just to explain you and give you an overview how it is drafted. And now I'll explain, we will proceed to how to state the facts and what are the relevant facts that you need to keep in mind if you get a case to file under section 125 CrPC. So then the prayer clause is followed by a verification clause, and then it is followed by an affidavit, wherein the petitioner states on oath that whatever I stated in my application or petition is true to my knowledge, it's correct, and it has been filed by my counsel under my instructions. I have read through the contents carefully. Now, so this is a basic draft of section 125 application. Now, just to go back to our slides. Yeah. So coming back to what are the essential consideration or key points that we need to keep in mind while we are drafting this. So after you capture all the basic details, the technical formalities, court name, party's name, title of the petition, then comes the main part of your petition and application, which is the facts. Now you have to keep this in mind, and whatever you may be drafting, you need to keep the basic principles of drafting, which is to always state all the relevant facts. Usually what mistake most of the lawyers do is that in a hurry they will file the draft, they will draft it without stating the relevant facts. And then even if they have good merits in their case, if they have not pleaded it in their petition or application, court may not allow them to argue on that point. So it is very, very important that before we, get to draft an application or petition, we have all the relevant facts in place. And therefore, a chronological sequence of events, which is usually contained in the list of dates is very important. So, always keep in mind that before you finally draft, you do your homework, read the provision, read the landmark judgments, read the latest judgments, right? And cull out the essential ingredients and the basic principles that you need to keep in mind. Because if you fail to ever or state those essential ingredients, your application or petition may ultimately fail, and you may not be able to get your client the relief that they wanted. So therefore, broadly in 125 petition, first and foremost, you need to mention the status of the parties, the relationship of the parties. For example, who is filing this? Your wife, or you are the child, or you are the parent. So you need to mention the status. Assuming you you are filing it on behalf of an estranged wife, a poor wife, then you have to mention that petitioner is so and so, got married, is the legally wedded wife of the respondent, or that she is divorced yet unmarried. Next, your fact should cover the details with respect to the solemnization of marriage, the registration details of marriage, details of the relevant rites, whether you have been married as per the Hindu rites, or Parsi Parsi rituals, or Christian rituals, or Muslim personal law. So you need to mention that under what personal laws you have your marriage has been solemnized. Next important factor is you need to mention the current status of the relationship between the parties. That are you still married, or you have remarried, or you are unable to maintain yourself, that you are a housewife, you have unfortunately you are not that educated, and therefore you are unable to get a job, and therefore this maintenance is more important for you. So these kind of facts you need to call out and mention in your petition, which will basically help your case to showcase before the judge that why you on what grounds you have a just case, you have a fair case of getting maintenance. Because the aim of this provision is not to penalize the husband, you know but the aim is to help a person who is not able to maintain herself or himself. So the court has to balance all the factors. While court wants to grant you the maintenance, court has to also keep in mind uh, you know uh, the financial position of the husband, the social status of the husband, the marital status of the husband, and on what basis the wife has been thrown out of the house, what are the background facts and circumstances. So always and always mention those facts, because you never know what relevant fact may let you win the case. So then next important factor in your petition is, like, what is the cause of action? Cause of action in simple terms means that what gives you the ground to file this application. So once you have stated that you are a legally wedded wife, that you got married as per so and so rituals, so and so personal laws, that in so and so you were married to that person for so and so time period, that this is your current employment situation, that this is your education qualifications. Then next comes the cause of action. Cause of action means that the wife has to state and explain that the relevant facts, that why she needs maintenance. Then these facts will include that the wife was perhaps thrown out of by the husband, her in-laws committed cruelty on her, maybe for dowry reasons or for whatever reasons. Then she was forced to live away from her in-laws house, which gave her the cause of action to approach the concerned court because she needs maintenance. So this is what the cause of action means. Now, this is next important factor is that a petitioner needs to mention that she is financially deprived as has no other means to maintain itself, and she is dependent on her husband's income right now. Then the petitioner also has to mention her husband's source of income, the financial status, and his educational background. All these details are important to state because court needs to understand that what amount should be fair and just and what amount court can direct your husband to pay. And in order to arrive at a fair and reasonable amount, court needs to know the entire background of the family, what is the current status of the financial position, how many dependents are how many members are dependent on that husband already. So all these factors are important. Now, next key consideration is, as I explained you, the jurisdiction clause. The jurisdiction clause is very important because sometimes lawyers make the mistake of filing it before a wrong court, and then that concerned court dismisses the petition, which is very detrimental to the petitioner's case. Therefore, you need to be very careful before deciding the court before which you want to file, because there have been cases where a lawyer is unable to ascertain the concerned court, and by mistake files it in a court which does not have the jurisdiction. As I gave you an example, that wife belongs to a district in Punjab. She is married to her husband who lives in Delhi, and after supposed divorce she now is currently living in Jaipur for some reason. In this case, if the lawyer decides to file this petition in the concerned district of Punjab, in that case, on the very first date, court may dismiss the petition because that is not the, as per section 126, 127, that is not the competent court to grant maintenance. So therefore, you need to be very careful, and you need to state in your application that on so and so basis, this is the concerned court, and this court, learned court, has the jurisdiction to decide this case. Then next, and the most important part of your application is going to be a prayer clause. Now, if a good petition will always mention a specific amount of maintenance. Most of the lawyers, what mistake they do is they draft a very vague petition. They are not able to state the relevant facts with which court can arrive at the relevant amount of maintenance, and or either they fail to state the specific amount of maintenance. In those cases, it is usually difficult for the court to arrive at a specific amount. And if a good lawyer always does that homework beforehand, and on the reasonable factors that you have already mentioned in your facts above, you state a specific amount. So if your lawyer is good, and I hope that after this session you would also be equipped with this basic technique and skill, and you will not make this mistake once you are representing a client, and you will do your homework and arrive at a specific amount. So for example, a husband is earning 1 lakh a month, and he has his elderly parents to maintain and one kid to maintain. So for example, if if you already have the bills of the electricity, the basic monthly expenses on food, grocery, etc., the fees which is given, which is paid for the kids. So all those expenses, if they come about, so for example, to 40,000, then 60,000 remains in the hand to the husband. Now in those 60,000, if you are able to show that for example, court will say, okay, 20,000 I am setting aside to maintain a usual lifestyle, then 40,000 is the amount which is free for grant of maintenance. So if you are able to give that crystal clear picture of the monthly salary and the expenditure of the husband, then court will be more inclined to give you the specific amount of maintenance. So therefore prayer clause is very, very important again. Now then the next important point is verification and affidavit. These are the technical requirements. After you have completed a draft, you have there a verification clause wherein you state that I am so and so party and I have read the above contents and I verify that this petition is true and correct as per my knowledge, and which has to be supported by an affidavit. If in case you are not still familiar with what an affidavit means, an affidavit is usually a very simple document wherein you state on oath before an oath commissioner. You execute this document before an oath commissioner, a gazetted officer, is stating that this application, the supporting application, has been filed under your instructions, and you have read through the contents, and on the basis of your instructions only, the lawyer has drafted it, and it has to be signed. Technically, it has to be signed in presence of the oath commissioner. Oath commissioner puts his seal, his authorization, then it has to be notarized. Once notarized, your application is complete, and there has to be some court fees, which varies from court to court. Once you pay that court fees, you are good to go, and you can file this application. Now, so this is an brief overview of what goes into a section, a maintenance petition. Now, if anyone has any questions so far, in this until this, you can raise it.
Interns, you can ask your questions. Sir, by the way, we have received 3 questions in the chat box. May I?
Yeah, sure. Please go ahead.
Okay, so the first question is, I think you were explaining about the husband and wife wherein the case. So the intern is asked, if the case is reversed and the wife is working but husband not, then who will pay the allowance?
So if I've understood your question correctly, Riddhi, so the question is, suppose if today court grants the maintenance and tomorrow husband has lost his job and is not earning any money, and the wife has started, in fact, on the other hand, wife has started earning. In that case, what will happen? Who will pay the maintenance?
Yes, sir.
To the husband or to the wife? So I'll answer.
Nisha, can you please confirm your question once?
Sir, actually, I want to ask if wife is working and husband is not working, then who will pay this allowance?
So, Richa, as I explained, and I'll just maybe take you back to the slide. So, Richa, in case if you have, section 127, if you have the Bare Act with you, if you read the section is very clear in such situations. And as I explained, that even suppose your case is decided and maintenance has been provided by the court, and in future if the situation arises as put forth by you, in that case the husband can approach the concerned court who granted that maintenance and can pray for cancellation of that maintenance order, because on the date, on this date, the husband has lost his job, he is not earning anymore, and on the other hand, the wife now is able to earn and is able to maintain herself. Now, Richa, I hope this answers your question, but again, just to further clarify, if you remember my first slide, wherein I mentioned the basic and the first essential, of seeking this, maintenance is that the person is unable to maintain herself or himself, right? So in your example, now that the wife has started earning, that means she is now able to maintain herself, right? So in that case, a husband can take benefit of section 125, 127 of CrPC and can approach the relevant court seeking cancellation of that maintenance order.
Okay, sir. Thank
Does
you.
that
Sir.
answer your question?
Yeah, thank you.
I'm glad.
Sir, the next question is from Tana. She's asking what documents are required to show that husband is not supporting anyone else.
Okay. So I'll answer that question with support, of a judgment. So actually, the reason I skipped this part, significant judicial precedent, because I was expecting such questions, and I'm glad Pranav asked this question. Very good question. Just give me a second. I'm just looking for the relevant slide.
Awesome.
Yeah. So as you see this slide, Pranav and everyone, so time and again Supreme Court has held that in these cases, as you can't have a documentary proof for each and every circumstance, right? Like for example, the question in Pranav's question inquiry, how will you show that how many dependents you have, right? So in that case, usually what we do as lawyers is, suppose if you have, you can maybe, request your parents, suppose a husband has elderly parents and two kids who he is maintaining and is supporting in addition to his wife. Now, in that case, what the person can do is he can request the parents to state this on affidavit that they don't have any other children, for example, and that they are staying with this ex person, right? So okay, just to put it like this, for example, Ram and Sita have three kids, three sons, but they are living with Lakshman, their elder son. Now Lakshman's wife files a case against Lakshman. Now the court will ask you, okay, Lakshman, what evidence do you have to prove that you are supporting your parents as well as you have your two kids who are staying with you and you are maintaining them. Now in that case, what documentary proof you can provide on record is that you can state it on the affidavit that you are maintaining your parents. At the same time, you can also state in such circumstances, any of your family members, close family members, or your neighbors can also support your case by stating this on affidavit. So for example, your neighbors can come to the court and state this on affidavit that so and so person is our neighbor, he is the only earning member in the family and he is supporting his.
Excuse me, sir. So are you there? I think he's facing some network issue and he's joining back.
I'm so sorry. I think there was some network issue.
No problem, sir.
Yeah. Wait, I'll just again share. Yeah. So does that answer Pranav's question? Like, what can be the documentary proofs and how you can support your case?
So actually, I was wondering what is the validity of these affidavits? Like, how valid are they in a court of law? I mean, at the end of the day, they are just statements.
Yeah. So, Kanak, interesting question. So as I was explaining, a petition always has to be supported by affidavit. Uh, आप लोगों ने यूजुअली देखा होगा, हम कोर्ट में हम जो कोर्ट रूम ड्रामा देखते हैं इन मूवीज एंड ऑल, anyone who goes into the witness box is required to take oath, uh, either of Gita, Quran, whatever is particular to that person's religion. So what is the entire purpose of that oath? So for that you will find the answer in Indian Evidence Act. So Indian Evidence Act says that if a person deposes something on affidavit under the oath in a proceeding, and if that statement later on comes about to be false, then that person can be prosecuted for committing perjury, which is a very serious offense under IPC. So therefore there's an assumption, and that is the reason a person is always required to execute this affidavit in front of the oath commissioner and a notary officer. So your affidavit is always executed in front of an oath commissioner and is notarized by the notary officer. And as per our procedural codes, an affidavit is considered to be true unless and until the other parties controverts and proves before the court that that person has lied on oath. So an affidavit will always say that I so and so, son of so and so, affirm this and state is on solemn oath. So that is the key essential. And if a person finds found out to be lying on oath, then that person can be prosecuted.
So, sir,
Does
are there any other documents that can support this statement? Like maybe some bills or, I mean, I don't know.
Yeah, definitely. So for example, if you're paying your kids school fees, you will have the fee receipts. At the same time you will have the electricity bill, water bill, Wi-Fi bill, because these are the now part of the basic lifestyle of a person. So if a person has all those bills, and if with the support of those bills and invoices, that person suppose has one servant or one nurse to take care of his elderly parents, that can also be produced before the court as a documentary proof to show that so and so expense goes into the salary for this nurse. So all these expenses can be supported by way of these documents.
Sir, Wi-Fi bill is also considered as a evidence.
So sorry, I didn't get your name. Nisha. Okay. Yeah. So Nisha, uh, now Article 21 of the Constitution, which grants us the fundamental right to life and liberty. Now, over the years, this article has been expanded by the Supreme Court and the High Courts and has been given a wide interpretation. Now, the basic right to life just does not include right to, food, shelter, and, food, shelter, etc., or house, but it also includes the basic necessities of modern life. So for example, if a person is living in a modern city, in a town, and he's working, for example, our post COVID days, now if a person is working from home, Wi-Fi is required, right? That is an expense. So ultimately what you need to show before the court is that I am earning 1 lakh a month, however these are my expenses. So for example, tomorrow, if you are spending your money in leisurely trips, or in suppose prohibited substances, then those might not be considered favorably by the court. because those such substances or such expense does not form part of the basic necessity of your lifestyle and of your requirement, right? So the expenses have to be just, fair, reasonable, and they need to be seen in the light of the basic necessity of a human being as per the modern life.
Okay, sir.
Does
Thank you.
that clarify?
Yes, sir. Yes.
Okay,
It's
thank
clear
you.
now.
All right. Any other question, Riddhi?
Yes, sir. The next question is, can this be filed before divorce has taken place or even before judicial separation?
All right. So thank you for that question. And again, a very good question. Uh, so, you know, again, I'll take you back to the basic principle of Section 125 CrPC. And therefore, you would remember, and I'm sure your professors must have also emphasized on this again and again rhetoric point, that always read your Bare Act carefully. Always read your Bare Act, because that will always have the answer to most of your questions. So again, answer lies in the bare reading of Section 125 CrPC. Nowhere it says that maintenance can only be sought by a divorced wife, or it can be only granted after judicial separation. All that it says is that a wife or children or elderly parents can seek maintenance as long as they are not able to maintain themselves. Now, to answer this particular question, assume a situation wherein uh, Robin and suppose Rita have gotten married and they have happily lived for 2 years. Now, for some reason, differences have arisen between both of them, and Robin does not want his wife to live with him any longer, and he might start beating up his wife, and because of which his wife is forced or compelled to go back to her matrimonial house and live with her parents, wherein she's not able to maintain herself, wherein the judicial separation is yet to take place, wherein they have yet to file for divorce. In that situation also, as long as she has not remarried, or she has not gotten a job, or she has not left the house for her own faults, she will be able to get the maintenance. So there is no requirement as such of judicial separation or divorce.
Thank you, sir.
Thank you.
So the next question is from Samar. He's asking, can a petition for maintenance be filed in the situation of a live-in relationship? And will it have the same procedure?
Brilliant. Thank you. Thank you for that question. And I'm glad that my slides have come to use to answer that question also. And I was expecting that question. Yeah. So can you see this slide?
Yes, sir.
Perfect. So as you can see this slide, so in the case of Chanmunia versus Virendra Kumar Singh Kushwaha, which is a judgment of Supreme Court rendered in 2010. The law, as the society has progressed, and our law has also evolved. Now, courts have made it very clear time and again that a strict proof of marriage should not be insisted as a precondition for maintenance under Section 125 CrPC. Now, what does that mean? So, court has clarified the definition of wife, provided under Section 125 CrPC, and I'll read it to you. That in construing the term wife, broad and expansive interpretation should be given to the term wife to include even those cases where a man and woman have been living together as husband and wife for a reasonably long period of time. Sorry. So, second, the ambit of the judgment now covers relevant relationships also. Subsequently, now there are n number of judgments which say that a man and a woman, cannot just walk in and walk out of a relationship. Can you see this part?
Yes, sir.
Where
Yes.
my cursor? Yeah. So court has, made it very clear that, live-in relationships between parties have to be considered. And if they're living for a continued long time, then they cannot be termed in as walk in and walk out. Then in such scenario, there will be a deemed presumption of marriage between those two persons. So, court has given live-in relationship the color of the deemed marriage, and therefore, if in such relationships, woman is not able to maintain herself, she can also approach the consent court. Now, it may depend from fact to fact, case to case, that what time period may be considered as live-in relationship by the court, right? So the time period has to be tested on a case to case basis. Hope that
And so,
answers.
so what would
Yeah.
be a reasonably long time? Because I think that's quite that's a little debatable topic, right? For some people, even a year is a long time. For some people, 10 years is a short time. So, is there a specific amount, or is it just according to the judgment of the court then?
Summer, usually, again, I mean, as I mentioned, there is no straight jacket formula. I mean, so far, there are no set parameters, that have been laid down by the courts to ascertain what will be a live-in relationship or not. That has to be seen from a case to case basis. So, for example, maybe there is a couple, a man and woman, who have been living, who have been dating each other, and they engage in physical relationship, and a woman gets pregnant with that man's child. Now, when a man gets to know that that lady is pregnant with his kid, then they, in order to take care of the pregnant of that lady during pregnancy, they might decide to live together. Now, suppose there might be a scenario when they come together to live together, and maybe just after a month or 15 days or maybe just a week, they decide that they, a husband starts beating beating up that lady, and then she's forced to live on her own in a rented apartment. Then in that case also, court may give that entire period of relationship, though they have been living in together for just a brief period of a week, but court might look into the nature of their relationship and may look it favorably for the lady, because they have been in a relationship for suppose 1 year, 6 months, and that lady is pregnant with that man's kid. So in that case, a court may allow that lady's petition.
Okay, sir. Thank you so much, sir.
Most welcome.
Interns, are there any other questions?
Yes, ma'am, I've posted one more question.
Yes, please.
So my question was, are the provisions available to men as well as women, and are they the same for both?
Sorry, what's your name? Can I know who is asking this question?
Yeah, my name is Khanak.
Okay. So Kanak, thank you for that question. Again, I'm glad you asked that question. Again, the answer lies in the section itself. The section clearly mentions that who can be the beneficiaries of this provision. Either it can be the wife or the minor or major children. And the third category of beneficiaries is the elderly parents. Now, fortunately, unfortunately, we don't have a gender neutral code so far, and therefore, as on date, this remedy and this social provision is only available to these three category of persons.
Okay, sir. Okay, thank you.
Most welcome.
Anybody else? Sir, I guess there are no more questions. So further, I would like
bored by
Sorry,
now.
Sorry, sir?
People, the attendees must have gotten bored by now. We have
No,
all,
not.
we have stretched to an hour.
No, sir. So further, I would like to proceed with vote of thanks. I, Riddhi Jindal, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to Mr. Tarun Agarwal, sir, for taking out time from your busy schedule and interacting with our young minds today. Thank you so much for joining today, sir. It was a wonderful session.
Thank you so much, Riddhi, and pleasure is all mine. And I just hope that and thank you so much for bearing with me for an hour. And I hope I'm able to answer your queries, and you have been able to understand the basic principles of Section 125 CrPC. Still, in case if you have any questions or follow-up questions, you may just send your queries to Riddhi, who can collate all the queries, and I'll be happy to answer all those queries.
Definitely, sir.
Thank you so much. Thank you so much for having me.
Thank you so much, sir.
Thank you, Riddhi.
Thanks a lot.
Thank you, everyone.
Thank you